Now, coming to our very first topic this morning, we're asking you, should people who provide character references for convicted criminals be expected to come to court to be cross-examined? One High Court judge in recent days has said yes. He made the calls for those providing character references in criminal cases. He said that they should be prepared to come into court and to be cross-examined and to justify why they were giving a character reference for for the convicted individual. Justice David Keane made the remarks during the sentence hearing of a man from County Tipperary who was found guilty of raping and sexually assaulting his son. Several character references had been provided to the court on behalf of the convicted man, including one from his parents and from his current partner. To discuss this morning, we are joined in studio by Tralee solicitor Pat Mann and Vera O'Leary, who's manager of the Kerry Rape and Sexual Abuse Centre. Thank you both for joining us in studio.
Morning.
It's great to have people coming back again into studio, notwithstanding the fact, as we're hearing this morning, that the University Hospital Kerry has had to introduce further visitor restrictions due to the rise in COVID cases. But anyway, thank you both for joining us this morning. I'll come to you first, Pat. What are your thoughts on this? That people who provide character references for convicted criminals, yes, they should be cross-examined. They should have to come into court and justify the reasons for providing those character references.
Well, I think, first of all, just on a very small technical point, and I'm not ever person for correcting anybody, I think it's not to come into court to be cross-examined. I think it's people who provide them should be available if the situation arises to come in and be questioned in relation to the reference that they give. So in other words, the procedure would be that if one were tendering references on behalf of somebody, say, who was about to be sentenced, you're obliged on the defence side to send copies of those in advance to the prosecution. And you would also have to file a booklet with the court office so that all parties would have knowledge of what's going in before the sentencing. So in other words, say the complainant then would know in advance what references are being handed in. And then people can say, well, I don't accept this and I don't accept that and I don't accept number 5. I think those people should be in court to be questioned on them. And if that is the situation, I agree totally with it. I agree with it on very basic principles. For example, let's say you were a road traffic matter and you had a very minor accident and you had a witness statement on the booklet of statements that said, yes, the driver of the car in front did have its indicator on. And then another witness that said, no, I was 2 cars behind, the driver in front did not have his indicator on. Well, you kind of would think it's only right that the people who are making the 2 statements should present themselves to be cross-examined on it. It's a kind of almost like a commonsensical point. So, bringing it back to basic principles, I would agree that would probably be correct law going forward. That's just my own view of it.
I'll come now to you.
But I don't want to be repeated, but I think it's to be available to be cross-examined if the other side say, well, I disagree with the contents of a reference.
Yes, but I just think we're debating as well, Pat, just the general issue.
I'd agree with what Judge Keane says.
Well, this is what the High Court judge said. The general principle that if someone provides a character reference for someone who's been convicted of a crime, should that person be available to come to court to be cross-examined? That's the principle that we're discussing this morning. Vera, I'll come to you now, Vera O'Leary, who's with the Kerry Rape and Sexual Abuse Centre. What are your thoughts on this?
I suppose I'd be speaking very much from the perspective of victims of sexual offences, and we know from their perspective that it demeans them, that it re-traumatises them. And I think there was a recent case where 23 character references were presented before the court for a man who had been convicted of sexual assault of his partner and one of the children. So I mean, that completely beggars belief. So, yes, I hear what Pat's saying, and from my understanding, that is correct. I mean, the bill, I think, is at the second stage, and it was Regina Doherty that brought this up, and she speaks very passionately about the criminal justice process being a very cold place for victims and survivors of sexual offences. So I think what we would like to see is, I suppose, first of all, I wonder what place do they have in the criminal justice process?
I was going to actually, I'm agreeing with you on that.
Yeah.
I was going to expand on that myself.
Yeah.
I think that they have a very, very small part to play in the whole thing in reality.
Yeah, and I think also, and I mean, Pat will know more about this, but we have heard from legal professionals that judges don't really take much into account, that they see it as a bit of flannel, and they don't take it hugely into account when you have that number of references coming before the court. So what we would like to see is, what Pat alluded to, is I think that the references should be made available to the prosecution and to the victim previous to the sentencing, so that they would have the right. But I think we need to, I suppose, look at it that it is so difficult in situations where it has been a contested case, where the defendant has been found guilty, where they're living in a local community, where then you have representatives coming forward and giving a reference to somebody. And I mean, it's always around that they're a good character. And the impact that has on the victim is really traumatising. So we would think if all that process was put into place, where the victim had more control, would know what was in the character reference, where their representative had the right to actually cross-examine or question, as Pat said, question the person that writes that character reference, I think that would maybe reduce the impact to some degree.
And Pat, can I ask you about what is the procedure at the moment, that if somebody has been convicted of a crime and someone submits a character reference on their behalf, does the victim, is the victim made aware of that? When do they find out that a character reference has been submitted on behalf of the person who has committed a crime against them?
It's a very, very strict rule of dealing with evidentiary matters, that whatever document you would intend, say on the defence side or on even on the prosecution side, to introduce, that a copy of that would be ran by the other side in advance of doing it. And
that always happens.
That always happens. And our local judge, Judge Waters, certainly wouldn't allow anything to be handed into court without asking, first of all, before I see it, have you shown that to the other side? So that has always been the situation. But can I just expand on why I'm agreeing with Vera? Can I expand on the thing on the basis of the principles of sentencing? You see, down through the years, in the not distant past, but in the recent past, when sentencing has become more and more not easier to judge, but more and more easier to understand, we have two blocks of things called aggravating factors and mitigating factors. So in every single case, whether there's a plea of guilty or a contested case, at the very end of it, when a judge is summing up, especially in the higher courts, which is probably what we really are talking about, that be the circuit court upwards, from the jury trials and so on, that all judges summing up have to say what the mitigating factors are and what the aggravating factors are, and they usually fall into bands then. So Vera is right that to a large extent the introduction of the character with references into the case really I think is at the lower end rather than even the middle end of the thing, because judges will know what their guidelines are in relation to sentencing. So it'll come always in around what the penalty should be anyway.
Yeah.
You know, that's the way it is, really.
Yeah.
You know.
I think Pat is right. I mean, judges have they will have those guidelines, and, they will look at the sentence, and they will have all the information in front of them. So I cannot understand. I think it's an old practice that I think there's a belief by, and no disrespect to the legal profession, but I think
disrespect to
I'd never do that, Pat. We know that, the accused are told to go off and gather as much character references as you can. So it's like, I don't understand that. I don't understand that practice, knowing that the judge won't take it into consideration. And it often then, when in the sentencing, the media cover these character references, so it places a doubt sometimes, even though the person has been maybe found guilty by a jury of their peers. It can place a doubt sometimes in the minds of people in society. This isn't really a very serious crime. This person, look, it was a mistake. They come from a good background. They have contributed a lot to society. So the actual crime becomes diminished. And what becomes more important is the character of the accused, and the victim gets completely lost in that process when they've just gone through probably the most torturous experience of their life, of having to sit in a court and defend often their character and their sexual history. So I really applaud the government for this.
Yes, But can I just say this, that take for example, I know most judges would disagree probably what I'm going to say, that there's no such thing as a victimless crime. But let's take a a crime where somebody, a man or a woman, very late in life, have, say, a problem with alcohol, and they're on their own, they're living on their own, and maybe people are not having contact with them, and they've spent a very, very good life, and let's say they had done a lot of charity, in their time that people didn't really know, but let's say they had done the old style churchgate collections, let's say they had helped people who were homeless, let's say they had helped in charity business and all that sort of stuff, and let's say latterly in life they fall in hard times and they become, say, somebody with a problem with alcohol, and they happen to take out of a shop a €15 bottle of whiskey and take it home, and they're stopped in the way and they're prosecuted for it. I think in those circumstances, I'm careful not to choose my language, even though it's technically the victim is the shop. But wouldn't it sort of serve the person, or maybe a judge, well to know that here's a person who all their life have had no previous convictions, who have worked in charity, and maybe have a letter you can hand into court from a local charitable organisation who could say, really, we understand that person's situation. So we thought, but, we shouldn't hard and fast close the thing down.
No, I totally agree with that, Pat. I suppose I'm talking about kind of the serious crimes, the sexual offences, where it can never be a victimless crime, the impact on the victim and the re-traumatisation. Yeah. And also, I think the broader ripple effect of the impact on society. And we know that, only a very small percentage, about 30% of victims of sexual offences report. Then we know it's much smaller. The attrition rate is huge. So that by the time it gets to court, the number is so small. So it's like, if we are to send a message out there to victims to come forward and report, saying that you will be protected within. And I will say the current government, and especially the Minister for Justice, Helen McEntee, she launched the third national strategy yesterday. She is really taking on board, and there is a lot of changes that are coming down the track. And hopefully this will be one of them as well.
I have to say it has improved dramatically.
Oh, absolutely, Pat.
In the last 5 to 10 years.
Yeah.
Vera, if I could put it to you now, Nolean Blackwell of the Dublin Rape Crisis Centre, she has been speaking to the Irish Mail about this, and she said that she would support this, that what we're discussing this morning, that people who provide character references for criminals be expected to come to court to be cross-examined. She said, what she said to the Mail was, every other part of a trial is tested, it's thrashed out, and there's a lot of cross-examination and questioning, particularly of the victim. She said, you then have character references at the end. I totally understand that you don't just sentence the offence, you sentence the offender. And from that point of view, the character references are part of our system, as Pat has so eloquently outlined there. But Nolean Blackwell of the Dublin Rape Crisis Centre says it's important that should be allowed to be tested. And she said that for victims that she's dealt with, the prospective victims, that when they hear that character reference, it's very hard to take these glowing or these comments made about their abuser or their attacker when it can't be questioned in any way, it can't be tested.
Oh yeah, I would totally agree with Nolean what she's saying. And I mean, we know from the victims that have to sit in court and hear glowing references, somebody who has committed a very serious crime and where they have been left struggling. And because our legal system, I mean, Pat and myself being known each other a long time, and God, some of the cases,
each other across court down through the years.
And some of the cases, and some of the ways the victims have been treated, God, it has improved drastically, but there is still a long way to go.
But sorry, Vera, but isn't that the point I was making a while ago, that if the documentation is furnished to the opposition, and you've maybe 5 items on the sheet, and the person could say, well, I let 1 be read, 3 be read, and 4 be read, but not 2 and 5. But just a purely technical thing, when you were talking about what Nolean Blackwell said about the evidence being tested, you must understand that, say, in the standard book of evidence, we could have about 80 statements on it. We only always, have only 3 or 4 witnesses out of that tested, to use that word, because the other 76 might be all routine witnesses. So that's the balance again in the discussion. That's all I'm trying to do, is bring it into it.
Yeah, and I also think, though, that the statements should be given, that there should be at least a period of time as short as possible because of the sentencing, but that the prosecution should have sight of these statements so that the victim can see them and that they can be represented and that it can then be challenged and that the judge
but in any
can.
case, I've been involved and we've always furnished them in advance, just to say that.
I don't know, is that...
We have done too many failures.
Yeah, I don't know, is that current practice all the time?
Well, I believe it should be. That's my own opinion.
Yeah, no, I would agree with
because
that.
Because it saves a pile of time as well by sending it to the other side. And but the new concept is what we're really dealing with today is whether or not the referees should be made available to be cross-examined. As a fundamental principle in law, I'd agree with that.
Just something, can I just say, because something that Pat said just triggered me, victims have the right to do a victim impact statement. That has to be furnished to the defence prior, and they can actually ask for some of it to be redacted, and she or he can be actually cross-examined on it.
Yes.
So why should it be like that for a victim, and yet not for the accused or the defendant?
Yeah.
Finally, you're both broadly in agreement that this would be a good idea. that those who provide character references will be prepared to come to court to be cross-examined if asked. Could there be any unintended consequences? That this seems like a very good idea, but could there be any unintended negative consequences at all, Pat?
No, from our discussion, I don't see. If a system is put in place and it has, say, across the board agreement, we have very, very good judiciary. They're very even-handed, I have to say. We've been blessed with a good judiciary since 1925. We've never had any real problems. And I always have to think they're very... And always never forget this. We have the 3-judge Court of Appeal, which was established only 2 years ago, all waiting above if for something that goes wrong below to come in and have it all sorted out, just to save the Supreme Court so they can be discussing far more important matters such as Brexit and our place in the EU and whether we should send more money to Ukraine and so on. So the Court of Appeal is there to deal with matters. So we have a rectificatory system in any event.
Yeah. No, I would agree with Pat.
Yeah.
I think it can only just have positive impact, not any negative consequences.
Well, look, thank you both for joining us this morning. Pat Mann, solicitor based here in Tralee, and Vera O'Leary of the Kerry Rape and Sexual Abuse Centre, giving support to that suggestion, to that proposal that people who provide character references for convicted criminals should be expected to come to court to be cross-examined if asked, and that it would only enhance and strengthen our legal and principles of justice in this country. Why we were discussing with this was that a High Court judge, Justice David Keane, made the remarks during the sentence hearing of a man from Tipperary who was found guilty of raping and sexually assaulting his son. Several character references had been provided to the court on behalf of the man, including ones from his parents and from his current partner. And Vera, if that triggers anything with anyone this morning, obviously the Kerry Rape and Sexual Abuse Centre are contactable at any time.
Yeah, they are. And our free phone number is 1800 633 333.